Hey there, friends! Welcome to Kids on the Block, where fun and imagination come alive. We dive into magical world filled with exciting adventures and awesome friends.
What position were you in?
I was number 2.
What position were you?
Number 1.
He decided to cross the bridge by his house and look for food on the other side.
We're going to do half cup of chocolate chips, and the other one, we're going to do half cup of the blueberries.
So, grab your imagination hats and get ready to explore with us. Join us every Saturday at 9 a.m. for new friends, amazing stories, and tons of laughter.
Join us as we explore the journeys of those who defy the odds and break barriers. We dive deep into the stories of triumph.
Sometimes when parenting a child with a special need or whatever disability, family life becomes a bit complicated and you may end up raising the child on your own.
Here, we inspire.
I have a farm which one we showcase with other dyslexic youths and autism how to farm.
Motivate.
It's never easy, but what we do, the best thing is to work with another parent who has an elder child than yours.
And break through the barriers one story at a time. Push your boundaries beyond the limit. Saturdays at 8 p.m. The Grind, where business meets brilliance. It's not just about the ideas.
I was working as a shampoo boy. I used to wash clients' hair on the sink.
It's about making them happen. From big wins.
In primary school, when we would be asked what people want to be, I was categorical that I want to be a nurse.
To hard lessons.
The consoles change, the gaming equipment keep changing.
We cover it all. Tune in to The Grind, where every episode is packed with insights.
The person who is serving customers, always be a customer-centric.
Strategies.
When you pay attention to detail, you get luxury items.
And stories to fuel your ambition. Don't just dream it, grind it. Mondays at 7:30 p.m.
Jiunge nasi tunapoangazia safari za viongozi bora. Kutoka kwa ushindi mkubwa hadi masomo magumu.
Wakati wetu kwamba wasichana si wa kusoma, ni wa kuolewa, ng'ombe ipatikane, wazazi wakuwe watajiri.
Tunashughulikia yote.
I wish I were a better investor.
My parents taught me how to look for things for myself.
Tazama Mfahamu Kiongozi, ambapo kila kipindi kimejaa maarifa, mikakati na hadithi za kukuza azma yako.
For me to succeed, I have to fight.
Kila Alhamisi saa 1:30.
Welcome back to the broadcast. You're watching To The Point. Thank you so much for choosing to stay with us. And right here in To The Point, as you know, we delve into the most pressing issues that affect our society. And tonight, we are talking matters of child support. This is a topic that affects most families as they try to navigate who gets custody for their child. And our guests are already here. We have Caroline Karuwitha, an advocate of the High Court of Kenya, who is already in studio with us. And we are hoping to have Wakili Collins Wanderi join us later on Skype for this conversation. Now, just to start us off, well, child support is always what is a child support, and according to the Kenya Law Children's Act 2001, this was, by the way, amended in 2022. Just a disclaimer as we start. And this is a legal obligation for a non-custodial parent to contribute financially to a child's upbringing. Now, you know, Caroline, when I put up this conversation on X earlier today, there's a comment that really caught my attention, and this guy said that we have no such term in the country as a child support. And with that, he was referring to, of course, that we are trying to emulate the Western culture. So what really is a child support in the Kenyan setup? First of all, do we have such a term?
Yes, we do, Anne, because when you look at the Constitution, Article 53, it talks about parental care and protection of the children by both parents. And when we talk about parental care and protection, child support is one of the responsibilities of both parents. So yes, we do have child support. Call it whatever you want to call it, but it is child support. And it is an obligation of both parents to take care of the child. Yes.
So what exactly do I need to know when suing for child support?
Well, what you need to know as a parent, one, let me start by saying that either parent can sue for child support. It depends with who has the child at the point of that application. And you see, most of these issues arise when parties who were once married are separated, or either they were not married, maybe this is a child who has been born out of wedlock. So you find yourself, you know, with a child, and the other parent is not taking of the care of the child. So you make that application as a parent of the child or as the guardian with the custody of that child at that point in time. So when you're making this application, what you need to know is that one, both of you, even as you go to make that application, whether, and most of the time it's the mothers, because when these, you know, relationships get sour, yeah, it's the mothers who go with the children or find themselves with the custody of the children. So even as a mom, when you're going to make that application for child support or maintenance, as the Act and of course the Constitution calls it, you have to know that you have an obligation. And when you look at the laws, they use words like joint responsibility or equal responsibility. So even as you walk to that courtroom, know that you have an obligation, even yourself. And that obligation is equal. And when you talk about equal, it may not be 50-50, but trust you me, you also have an obligation. So yes.
You've mentioned quite an interesting point, and we have it here. We'll be getting into it later on. But when you say that mostly mothers are lucky enough to get custody of the child, so do we say that when it comes to going for child support, the mothers are mostly favored?
Not really. Actually, the straight answer to that question is no. Because, like I said, the law is very specific on the, you know, the equality of their obligation. So the answer to that is no, they are not favored. It's only that when it goes to court, remember the court asks the considerations that he has to look at when making that order. So one of these considerations is you have to look at the financial capabilities of both parties, their income, their source of income. And number two, you have to look at their expenses as parents, and also look at the children need or the child needs. So you're comparing or you're putting in a basket all these things before you can make that order for child support, right? So it is not a favor to one parent, and especially it's not the mothers, because all those considerations have to be made by the court. What is this parent, if it is the mother who went to court to ask for child support, the court will be looking at what is the father, what is the income of the father, right? And also what is the income of this mom who is coming to court to ask for child support. Now the next thing we're looking at is what are their expenses, because before you tell the father to pay 100,000, say, in school fees or even in maintenance, do they have other obligations? Remember, this is a person who has a day-to-day expenses. Also, they may have other, another family, another child somewhere to take care of, right? So the court has to consider their expenses also, then the needs of the child.
Right.
And having considered all those things, then it is able to make a considered decision as to how much one parent or the other parent is contributing towards the maintenance of the child. And we've had so many authorities where the courts have ruled maintenance is not for purposes of punishing any parent. A child should be raised within the means of the parents. Yes.
So when it comes to child support, the custodial parent's financial capability comes to play when making this decision in court.
Exactly.
All right. Now let's take a look at the types of custody that we have. We have legal custody. This is simply the right to make significant decisions about a child's life, including education, healthcare, and religious upbringing. Now, who is the legal custodian? Wakili.
Again, both parents are the legal custodians, and when you look at the trend, again, of decisions made by our courts, is that mostly legal custody, as you've put it, is the decision-making aspect of child custody. So it is given mostly as a joint, legal custody is given jointly to both parents. Yes.
Let's take a look at the second one. Sorry to cut you short. We have physical custody, and this pertains to where the child lives and the day-to-day care of the child.
Yes.
I want to understand, you see these parents who deny the other parent access to their child. So does the law really come to play, or just kuingilia kati? Tukisema, when I deny my partner the chance to see their child, how does that work?
Actually, denying the other parent a right to see their child, right now under the current Children Act 2022 is an offense. And you can actually be charged, and I think the imprisonment period is 1 year, and there's a fine of 500,000. So yes, it's an offense to deny the other parent a chance to see their child. So what happens in physical custody, like you put it, it is the actual physical place where the child, with which parent is that child going to stay with, under the circumstances now that both parents are not living together. So the parent who has physical custody, or who the physical custody is given to, then should allow the other parent to have access. So even when the court is making that order for physical custody, it will definitely make an order for access, because it is provided for under the law, and the child has a right to maintain a relationship with both parents, even when they are not living together. So if one parent has physical custody, the other parent has a right of access, and the modalities, of course, will depend on the circumstances of each case, but most of the time you find it's since these children will be in school at some point, then access is given on alternate weekends. And again, it will depend with the mode of custody that has been given. Remember, it can be shared. Nowadays, it's not an issue. By the way, in the previous act, there was a provision where children of tender years, that meant a child of 4 years and below, and especially where the children were, female gender, they were given the custody, physical custody was given to the mom. So it meant now it's the father to get access. But with the current act, actually that definition for tender years has been removed completely, meaning either parent, it doesn't matter how old the child is or what gender the child is, either parent can get physical custody of that child. It depends with the circumstances of every case. So once you have custody of the child, then the other parent will have access. Now assume this custody is shared, so that in 1 week the children are with the father, the other week the children are with the dad. In that case, of course, there would be access, because either parent is able to have access of the children 50-50. Then when it comes to holidays, again, the trend is that holidays are shared when it comes to access. So I think there's a balance in law.
When you say that right now any parent can get access to the child,
exactly.
That 3-month-old child, 1-year-old child, don't they breastfeed when maybe this child is given to the father? How does that now work?
Now, if is a child, like we use your example, a child of 3 months old. Now, let me ask a question because you're having a conversation.
Right.
Assume that mom is a drug addict. You see? So that child may not go to the dad, but there are provisions on how then the custody of that child can be placed in a alternative care where the child will be taken care of, if the mom is not in a position to take care of the child. But of course, a child of 3 months, like I said, it depends on circumstances. She or he will remain with the mom, unless of course there are extraneous circumstances where the mom, like I mentioned, maybe drug abuse or immorality of any form of exceptional circumstances that will lead the mom being denied access to custody to such a very young child. Yes.
All right, Wakili Collins Wanderi is already set. And Wakili, karibu sana to TV47. Thank you for joining us. We are talking about the types of custody. And right now we've touched on physical custody, we've touched on legal custody, we've touched on physical custody. Right now, we want to talk about sole custody, Wakili, and this is one parent has both legal and physical custody of the child. The other parent typically has limited visitation rights. Now, when making such a decision in court, when you are giving a limited visitation rights to one particular parent, how do you make such decision, Wakili?
Good evening, viewers. That's a very good question. Number one, there are circumstances under which a child can be placed in the physical custody and the legal custody of one parent. And one of the circumstances is the ability of the court will look at the ability of the two parents to look after the child. And sometimes the court will go into issues of who has the means in terms of finance, who has a house, who is mentally stable, and who would, in the best of the circumstances, look after the child. The underlying principle here is that the court will always look at the
Well, we are losing you, Wakili.
Interests.
We are losing him. All right. All right, we'll be coming back to you in a few, Wakili. But let me engage Wakili Caroline just in the same light, right? Now, joint custody, let's continue with that. This is where both parents share legal and or physical custody of the child. This basically encourages cooperation in parenting variations. How does joint custody work in practice where parents post separation? How does this work?
Well, it works and it's working. And the way it works is that at the point that joint custody order is being made, of course, the court has made assessments of how best to serve in the best interest of the child. Because if, assuming the children are in, a boarding school, the only available time those kids will be at home is during the school holidays, right? Now, that would be very easy because the parents will be sharing the children during school holidays. But when it comes to joint legal custody, then decision making, it's a matter of consultation. Remember, co-parenting is actually consultation. Because once you have a child together and you're separated, you remain joined together by this child. So you definitely have to consult on where the child is to go to school, which church the child is to go now that, you've gone your way, maybe you're a Catholic, the dad is an SDA and all that. So it encourages communication for joint custody, especially, a lot of it. Now, in terms of assuming the children are in the school, now, like I gave an example earlier, you may have these children staying with one parent for 2 weeks and the other parent for 2 weeks. Now, what happens here is that when you have the children, for your 2 weeks, you take care of all the basic needs. from food, shelter, clothing. You know, you have your own set of uniform in the house. You provide for transport to and from school, you know, when the children are coming from your house to and from school. Now, when you hand over the children to the other parent for the other half, half of the month, that is the other 2 weeks, that other parent has the responsibility of all the basic needs of the children. So that then when at that point in time, there's no much, you didn't bring the school uniform, or I don't have food in the house. So at the point those orders are being made, all those things have been assessed and looked at and considered. And of course, part of the order will be that when you have these children for these 2 weeks, you take care of all the basic needs. When you have these children for these 2 weeks, you take care of all the basic needs.
All right. Now, Wakili Wanderi, what happens when one parent wants to default?
Please ask your question again.
What happens when one parent wants to default in terms of joint custody?
Now, that means that one of the parent who defaults is inviting a legal case. Most times, joint custody is granted by court if for one reason or another the parents are unable to agree or unable to live together. Now, often courts will not impose their views and decisions on matters of children. Courts often ask parents to agree, and then whatever their agreement is, it is recorded as a consent before court, and that becomes the order of the court. That is the experience we have. And when one parent defaults, that means then the parent who is wronged now has to go back to court, and there are penalties for that. Because in the event that you refusing to hand over the child, then if you go back to court, the court might as well rule that even the period you are supposed to have the child, you will not have that child. So often many people, as my colleague Caro is saying, it is working for those parents who agree to disagree. Remember, the children are innocent they're innocent. They're usually caught up between disagreements between parents. And that's why courts will not be bothered by the feelings and emotions that surround physical and legal custody. They will always focus on the best interests of the child. And if a parent, for example, becomes belligerent and becomes difficult to deal with, we have had circumstances where the court has actually ruled that such a parent will then not get access until they redeem themselves, until they demonstrate that they have the capacity to make because remember, both children have a right to both parents. There is no one parent who has superior rights over the other. They are all equal under the Constitution and the law. And even morally and in any other circumstance, two people brought the children into this world. So they should not, it's not just a question of financial burden and responsibility, even in terms of access, upbringing, care, custody, and maintenance, they are equal.
All right, thank you so much, Wakili, for those insights. We are taking now a very short break, but when you come back, Wakili has mentioned that children have rights to their parents, but do they have the right to choose which parent they want to go with when they are in court after this break?
Hey there, friends. Welcome to Kids on the Block, where fun and imagination come alive. We dive into magical world filled with exciting adventures and awesome friends.
What position were you in? I was number 2.
What position were you?
Number 1.
He decided to cross the bridge by his house and look for food on the other side.
We're going to do half cup of chocolate chips And the other one, we're going to do half cup of the blueberries.
So, grab your imagination hats and get ready to explore with us. Join us every Saturday at 9 a.m. for new friends, amazing stories, and tons of laughter.
Join us as we explore the journeys of those who defy the odds and break barriers. We dive deep into the stories of triumph.
Sometimes when parenting a child with a special need or whatever disability, family life becomes a bit complicated and you may end up raising the child on your own.
Here, we inspire.
I have a farm which one we showcase with other dyslexic youths and autism, how to farm.
Motivate.
It's never easy, but what we do, the best thing is to work with another parent who has an elder child than yours.
And break through the barriers one story at a time. Push your boundaries beyond the limit. Saturdays at 8 p.m. The Grind, where business meets brilliance. It's not just about the ideas.
I was working as a shampoo boy. I used to wash clients' hair on the sink.
It's about making them happen. From big wins.
In primary school, when we would be asked what people want to be, I was categorical that I want to be a nurse.
To hard lessons.
The consoles change, the gaming equipment keep changing.
We cover it all. Tune in to The Grind, where every episode is packed with insights.
The person who is serving customers, always be a customer-centric.
Strategies.
When you pay attention to detail, you get luxury items.
And stories to fuel your ambition. Don't just dream it, grind it. Mondays at 7:30 p.m.
Jiunge nasi tunapoangazia safari za viongozi bora. Kutoka kwa ushindi mkubwa hadi masomo magumu.
Wakati wetu kwamba wasichana si wa kusoma, ni wa kuolewa, ng'ombe ipatikane, wazazi wakuwe watajiri.
Tunashughulikia yote.
I wish I were a better investor.
My parents taught me how to look for things for myself.
Tazama Mfahamu Kiongozi, ambapo kila kipindi kimejaa maarifa, mikakati na hadithi za kukuza azma yako.
For me to succeed, I have to fight.
Kila Alhamisi saa 1:30.
Hey there friends, welcome to Kids on the Block, where fun and imagination come alive. we dive into magical world filled with exciting adventures and awesome friends.
What position were you in? I was number 2.
What position were you?
Number 1.
He decided to cross the bridge by his house and look for food on the other side.
We're going to do half cup of chocolate chips, and the other one, we're going to do half cup of the blueberries.
Welcome back to the show. You are watching To The Point, and our conversation tonight is on matters of child support. Before we went on that very short break, we were taking a look at the types of custody, and we have legal custody, physical custody, sole custody, joint custody, and split custody, as you can see on your screen. And Wakili Wanderi made a very important comment right there, that children have rights to those parents. And my question to you, Caroline, is do these children also have the right to choose the parents that they want to go with?
Well, let me say not a right to choose the parent they want to go with per se, but they have a right to have their views heard by the courts. Because in every matter, like the main principle is that every matter relating or concerning to children, then the best interest of the child should be paramount. And one of the considerations is being able to hear the ascertainable views of the child. So you find that in most of these cases, where a child is a child that can actually express themselves, the court will actually interview those children. And part of the questions they are asked is, which of the two parents they would like to stay with, and they express themselves. So yes, they have a right to be heard, and they are heard. Yes, and when they say, of course, the courts have held that those opinions are actually not the main determinant of where the child will go, because the choice of the child sometimes may not be in their best interest. So at the end of the day, the court will consider the best interest of the child, but yes, the views of the child will be considered.
All right. Now, Wakili Wanderi, what factors do you typically consider when determining custody arrangements?
Now, one of the main things that is considered is whether the child will be in a safe home. You know, when we are talking about the interests of the children, one of the major concerns by the court is the safety of the children. Apart from safety, then we have the ability for support. Then the other thing, remember that some children are school-going children. So you cannot place children in obvious difficulty because of considering the interests of one parent. So sometimes we have had situations where one parent is considered to, or is given what is called loco parentis. That is the parent who is nearest to the facilities like a hospital, school, where the children go. So that parent enjoys what you call loco parentis. That does not mean that the other parent is defranchised. But then you see what my colleague Caro and I are insisting. The primary issue is always the best interests of the child. Where they go to school, sometimes it's about their religion, where, for example, they can go and worship. Two, where they go to school, where they can get medical facilities. If, for example, you could even have a child with a congenital problem, was born with a problem, you would not expect a court to take that child, for example, if one party was working for the UN in Garissa or Lodwar. Now, you see the issue here. So the issue will be that the child will be where they can be the best taken care of.
All right, let's take a look at the legal obligations to maintain the child. And we have both parents, whether married or not, share the responsibility to provide for the child's need. Both parents contribute regardless of their marital status or living arrangements. And either parent can petition to the court for a child support order if the other fails to fulfill their responsibility. And if a child is not maintained, both parents can be legally held accountable. Now, Wakili Wanderi, let me just stick with you right here for a moment. How does the law ensure that both parents fulfill their responsibility to maintain the child rights?
There are two ways to do this, or let me say there are three ways. Number one, the two parents can agree to agree, and they lay down the rules on how they will share the custody and the other responsibilities. And often we have parents who agree, and sometimes we do an agreement known as the parental responsibility agreement. And that parental responsibility agreement is signed by both parties, outlining the duties and responsibilities of each and the obligations towards the children. Now, the other way that this determination of who takes care of what is through the court. A court can order that, for example, this child needs to go to school. This parent will contribute this, and that this other one will contribute this. And how does the court determine that? The court determines that using information provided by both parties. And both parties can provide information through what the court calls a means test. In other words, the ability of either parent to earn a living and to contribute their fair share in matters of the children's upkeep. The third one is where both parents are destitute. You have had situations where children have been neglected. It's good that we mention this, that children have been neglected because one parent is a vagabond, is a drunkard, is a drug addict, the other parent is also unavailable. The court can appoint what they call a guardian ad litem. That is a temporary guardian to look after the child. And often you will find that children's homes, I think my colleague had touched on that, children's homes do get that right when the court says that we want to place the child in a children's home. That means now children's homes thrive on the goodwill of donors and sponsors. So that is the third way a child can be taken care of in terms of their needs.
Now, Wakili Caroline, do I have the option of coming back to court if my partner is showing non-compliance?
Exactly. You can go to court for enforcement, because like any other court decree, when an order has been made by court, it is meant to be complied with. Now, if one party does not comply, the other party, who is the custodian of the orders, should go back to court, apply for a notice to show cause, and that person who is not complying will be summoned in court to come and explain why they have not complied with the orders. And in this case being orders of child maintenance, the court will have the obligation now to ascertain, because most of the time you hear, I have not complied because I am not able. So there are two ways, there are two things. One, the person, you may say, I am not able to provide, I have no source of income. The other side, the court will be looking at, because the court is looking, is it the inability or is it the refusal to comply? So if it is refusal, then the court will, of course, put in place enforcement mechanism. You can be committed to civil jail until you comply. The court can even order a sale of your assets after they have been ascertained that you actually have something to use to provide for the child, but you are refusing to do it. Then the court will order an investigation into what you own. And if it is ascertained you have some properties, the court can actually order a sale of your properties. So the first thing the court looks at when that notice to show cause is, the application has been made, you've come to court, then is ascertainment of the means, then it establishes whether or not you are able to provide. If you're able to provide, then first enforcement mechanisms follow. Then if you are not able, because remember, it is about the ability to provide. So is this person really able or not? You may have, when the orders were made, you may have been employed. then the next thing we know, you're jobless, you see? So all those things the court will consider before it makes any enforcement, it takes any enforcement measures. But yes, you can go back to court and the court will definitely enforce its orders because orders are not made in vain.
Wonderful. Now, as much as we're talking about these parents, we also have this child right here. As you make this, as the court makes this decision or ruling, how is the mental well-being put into consideration?
Well, one, that's why children go to court through their parents or through their guardians. They are not, the child will not necessarily be there to make that application for themselves. The court tries as much as possible to protect these children.
Let's talk about that child who is now of age to make his or her own decision.
If the child is of age to make their own decision,
14, 12.
Okay. Now I understand, because if you say they have age to make their decisions, then they'll be 18 and they will not be represented by the parents, they'll be going to court by themselves. But now when you talk about a teenager of maybe 13, 14, 15 years, these are children who are now being called to court for an interview. And the court will give them an opportunity, it will listen to them, and of course they want to understand where they want to stay, you know, what are the things that maybe offend them about one parent or another. But in terms of maintenance, of course, when two parents are fighting and this child actually understands everything, definitely you expect that the mental, you know, and the emotional and the psychological aspect of that child is affected. And many a times the courts have actually ordered for these children to undergo counseling because that process is actually traumatizing. Remember, we're dealing with parents who are already separated. They are bringing emotions into these cases which they are not supposed to be bringing, but I mean, these are people who are, you don't know what this person did to this other person. And in as much as we try our best to tell them, please don't bring your emotions into the case, the things sometimes are out of control and all those things are brought in court. You find some files are so big, not about the issues of the children, but what this other person did wrong to this other person. So in those cases, the children are really affected, and the court at some point makes orders where the children have to go through counseling. Yes.
You've also mentioned that a child, somebody is 18 years old. Of course, in Kenya, he or she is not considered a child.
Yes.
But you've said that they can go to court themselves.
Yes.
So an 18-year-old plus can sue for child support. Or what is the duration of child support?
First, the duration of parental responsibility, the law is that parental responsibility ends on the 18th birthday of that child. But then there's an exemption to that particular provision. There's actually an express provision where a child can apply for extension or parental obligation. Of course, that child who is 18 years can make an application by themselves, or the parent who has actually been making the other applications can still make an application on their behalf, seeking extension of parental responsibility. And of course, there are considerations to be made. And an example is where a child is a special needs child whose needs now, financial needs, will exceed the 18th birthday. There are those children who are still in college. That still their financial needs will exceed the 18th birthday and other, you know, circumstances. So yes, the child at over 18, you can make an application for extension or parental responsibility, so that the parent who has been providing for your education, if it's about education, it's about medical needs, can be ordered by court now to continue providing for the child to some extent. So that period is extended from 18 to a certain period. It can be 20, 21, 25. Yes.
All right, let's take a look at the demographics of child support application in Kenya. And according to the KNBS, that is the Kenya National Bureau of Statistics, historically, women who are custodial parents have been more likely to apply for child support. And recent reports suggest that about 75 to 80% of child support applications come from mothers seeking support from fathers. Now, Wakili Wanderi, does it mean that most men do not go to courts to file for child support?
That is the position in Kenya. A lot of men do not go to court. And you see, there is also the way our society is socialized. The socialization is that the primary responsibility of looking after the family belongs to the father. And consequently, you have a situation where even where the mother is earning or has means more than the father, a lot of men will not go to court. But however, the situation is changing since 2010, 2014. There have been new laws that have made it possible for men to go to court and apply for support. Because as Carol has said, a man can lose his job. A man can also be injured in an accident. He can also become disabled for whatever reason. He can also become insane. And therefore, he also needs support from the other partner, as well as the children. But however, there is something Carol mentioned about extended parental responsibility. Extended parental responsibility, for example, if you have somebody who has gone to university, to a private college, and one of the parents has been paying, it is presumed, there is a presumption by court that that parent will continue to look after that adult, young adult, until they are capable of looking after themselves. Perhaps after they've completed college and they have gotten some work to do or a means of livelihood. However, it is not automatic that a parental responsibility can be extended. There are obligations on the child on anybody above 18. You cannot demand that your parent looks after you. There are obligations set by law. Number one, you must show respect to your parents. Number two, you must not cause conflict in the family. Number three, you must not engage in behavior that is unwanted. For example, there are people who have certain religious practices, certain cultural practices. If you want to depart from those, then you cannot ask your parent to continue providing for you.
All right, and the geographic distribution of applications in the country when it comes to child support, applications are more prevalent in urban areas compared to rural regions, where traditional practices may sometimes influence parenting responsibilities and support obligations. Caroline, there has been also an increase in cases of child support where people sue. Why has there been so much increase?
Well, let me just say it's because the only reason one parent will go to court suing for parental support is because the other parent is not taking their responsibility. That can be the only reason. And of course, we have increase in population, so children are being born every single day. And if now one parent does not take, and of course, we are talking about an economy that is, you know, just the other day, 1,000 shillings you'd have gone to a shop and, you know, shopped a lot of things for that child. Right now, you go to a supermarket and all you come out with maybe is a few packets of milk. So this person who felt I would have raised this child by myself, but at this point in time they feel I really need support from this person, and even if, you know, they have not taken care of this child since they were born, maybe now the child is 10 years, there's need now, they feel the need now to have this other person come on board and support them. So I would say it's about the increased population. There's of course the economy, you know, and the fact that in urban areas people are more enlightened. They know the law, you know, and we don't have this something that Mr. Wanderi has spoken about, you know, the social aspect of where the man feels that the burden of taking care of the family is on the man, and they may feel even they may be afraid to go to court asking for support from the mother to the child. So they carry that burden alone. But in the current, I think as times keeps changing, everybody feels that everybody has a responsibility under the law. So there's that enlightenment in urban areas. But when you go to rural areas, even the stigma itself does not allow those women to go to court and start asking for support. Yeah, so I think there's a lot of, in rural areas, there's a lot of stigma. There's also the social aspect of the fact that a mother should take care of the children, you should take care of the family, you should take care of the home. So I think that's
hold it right there, Wakili Caroline. And of course, as we engage Wakili Wanderi, before we let you go, one of the challenges in child support enforcement, we have delays in legal processes. So there's also a question of interest in the point of gender disparity, of course. Wakili Karitha had already told us when it comes to the law does not really favor women, but right now every parent has access to the child. Now, delays in legal processes, how can we address this matter, Wakili?
Number one, as I said earlier, when people go to court, it means they are unable to agree. If they are able to agree, then they would need to go to court. However, remember, as we said, when again you go to court and seek custody or maintenance orders, the court most of the times requires the two parents to go and talk. And I can tell you personally, I've had a case where the magistrate said, you go to the children's officer who becomes an arbitrator and listens to both parties, makes a report, and hands it over to court. I can tell you that that case was determined within a month. That is how fast it can go. In other words, the courts have opportunity to use alternative dispute resolution, that's ADR, and mediation for the parents to come to a compromise and understanding, especially on matters of custody and maintenance. So courts will be they are very slow to impose their own decisions. Now, what makes the process slow is where you have belligerence. And as Carol said, there are parents who emotionally are still fighting. They have not come to terms that perhaps their marriage has ended. They have also not come to terms their relationship has ended. And therefore, they want to use the children as pawns in the game. So you will find applications upon applications, counter applications, and then the court is then juggled with a lot of applications. And to hear all these, that is what causes delay. But let me also say this: it also determined by the way, again the advocate you approach. We have different philosophies. In our practice, there are those who want to fight over everything. We call it the Scotch art policy. You must fight and win. Then we have those who believe in mediation and arbitration. And even court has what is called the court annexed mediation. And what happens is that you have lawyers who do not believe, also because of the philosophy they hold from their school of thought, that they can let go. In other words, they get subsumed into the dialectics and the arguments between the parents. That is a bad sign. In fact, for most people, parents who, if you encounter an advocate who wants to tell you to fight to the end, and it's over children, please, you need to determine whether you actually need the fight or you need your child taken care of.
All right,
as I've said,
thank you so much, Wakili. Thank you so much, Wakili. Due to the interest of time, let's just get final remarks from Caroline Karitha. Of course, thank you so much, Wakili, for your time. Is it expensive to sue for child support? Of course, briefly in a sentence as we close.
No, the simple answer to that question is no. Actually, there's no fees for filing a children case in any court in this country. There are no fees. The only fee you pay is just to extract that order. I think that's the only fee I've paid in children cases. So filing children cases is free. The only fee now you, of course, pay for is the legal fees for your advocate that you engage. And again, it will depend with your agreement with your advocate. In as much as there's the advocate's remuneration order, and I believe it's not expensive.
All right, so the advocates call the shots, right?
Yes, yes.
Thank you so much. That's all you need to know when suing for child support. Thank you so much for watching. Thank you, Caroline and Wakili Collins Wanderi, for making time for this very important conversation on child support. My name is Anne Odida. On the sign language interpretation desk is Kelvin Makori. Thank you so much for watching and see you next time. Have a wonderful night.